Paula Reed, I know you've been listening to this decision. What have we heard?
We have. Of course, this is not a thumbs up, thumbs down. This is a complicated decision. We just got it here. It's an opinion from Chief Justice John Roberts finding that former presidents are entitled to absolute immunity for official acts, but not for unofficial acts. So what does that translate to? Well, this is something we saw that was sort of signaled in oral argument, because what this means is that the former president cannot be prosecuted for anything that was officially part of his job when he was in office. And that's significant because even his own lawyers conceded during oral argument that not everything that is alleged in this indictment was an official act. So now the question is, what does the special counsel do here? He could potentially try to cull down this indictment to a more narrow one, just focusing on unofficial acts, and then try to proceed with this case. Still an open question, though, about whether even a slimmed down case could go before the election. 3 reasons for that. One, the judge overseeing this, Judge Tanya Chutkan, she has signaled that the lawyers should get some lead time on this. I mean, we're a couple months out from the election. The idea of putting the Republican candidate for the presidency on trial, where he would have to be in court months, weeks before the election, that's something that would likely have us right here again before the Supreme Court. Also, the Attorney General, unlikely to allow something to go ahead that quickly, but we'll see. But right now, this decision, the Supreme Court finding that former presidents are entitled to absolute immunity for official acts, but not for unofficial acts. This opinion, very, very long. It's going to take us a while to get through everything.
Right now, I'm looking at an excerpt from the Roberts written decision. He says, quote, Trump asserts a far broader immunity than the limited one we have recognized, meaning the court. The text of the clause provides little support for the absolute immunity claim that Trump asserts. So they're rejecting that. But in essence, all of the details as to the allegations made, the accusations made in the Jack Smith indictment of Donald Trump, not all of them, but many of them, the court is saying, we are sending this back to the district court. They have to decide whether Trump's communications with the American people, calling them to rally to the Capitol on January 6th, and everything that happened after that, the disruption of the counting of the electoral votes, the sham electors scheme, all of that, whether or not that's an official act, has to be determined by the U.S. District Court. And Ellie Honig, you were saying what's most significant about that is the U.S. Supreme Court could have said, we're remanding this to the district court, to the lower court, and whatever they say goes, and we will uphold that. They didn't say that.
Exactly. To the contrary. This case will not go before the election. It will not be tried before the election, and here's why. The Supreme Court has just said there is such thing as criminal immunity. The test, as we anticipated, is essentially official acts versus unofficial acts. We're sending it back to the district court, and this is an important detail, the court says several times, whatever the district court finds can be appealed before trial. Jack Smith had made an argument of, well, maybe the district judge, the trial judge, can work it out and send it to the jury, and then the jury can separate official from unofficial acts. Several times in this opinion, the Supreme Court, the majority, says explicitly whatever the judge decides about what's official or unofficial, what's immune or not immune, that can be appealed back up. 0% chance that happens before November.
So why do that? I mean, if they are saying, hey, we're the U.S. Supreme Court and we're going to have the final say on this no matter what, why not just make it clear? Everything's delineated in the indictment. Why not just make it clear? And if Judge Chutkan decides X, Y, or Z, we will agree with that. Why not just be explicit?
Because the Supreme Court, they're in a court of appeals, they want to see a record. Right, and I think with Judge Chutkan just kind of dismissing out of hand all conduct whatsoever, the president has no immunity for all criminal conduct, for any criminal conduct. They've gone back and said, no, you need to go look at this, and then come back to us based upon what we've said in this opinion.
And the other thing is, well, it's the right and rules governing when and how to appeal aren't set in stone or aren't entirely clear. And I think they felt some need to delineate that this is an appealable order. They aren't always, and sometimes some things you have to wait to appeal until the end of a trial. They're giving whoever it is, and probably Trump, the opportunity to appeal during trial.
Well, let me ask you, do you think that if Judge Chutkan had ruled differently initially and said, basically closer to this, the conversations with the Justice Department are clearly official acts, I'm not going to count them, but the other ones, like if there had been a less of a sweeping, of course he can be indicted on any of this stuff, ruling by Judge Chutkan, would this not have been ended up where it was today? Did she open the door for a decision like this?
She did. I think Judge Chutkan's going to have a lot of regret. When she issued her opinion, it just said there's no such thing as automatic immunity for everything a president does his whole 4 years. When I was reading that, I said, okay, where's Part B? I expected Part B to be, and I find, having reviewed the record and reviewed the documents, and I find that even if there is such thing as immunity, he was outside the scope. And by the way, that's what the Court of Appeals did on their ruling. The problem is, as Jim was saying, the Court of Appeals and the Supreme Court, they're not fact finders. This can only be done at the district court level. And so I suspect Judge Chutkan is feeling some regret. It wasn't like it was some leap of logic that she should do that. This happens. There are hearings. For example, in the Georgia case, Mark Meadows is trying to get his case moved over to federal court. The question there is almost the same thing. Was Mark Meadows in or out of the scope? You know what the federal judge did there in Georgia? He held a hearing. Mark Meadows testified. He said, I find, based on this hearing, you're outside the scope. If Judge Chutkan had done that, we'd be in a very different position.
Where I don't agree with that, though, is that either of the parties would have had an opportunity to appeal the portion of that opinion that they did not agree with, because it would have been somewhat of a split the baby gobbledygook that they would have had a right to appeal. You can't tell me that either Jack Smith or Trump's team would not have attempted to take it up, and the Supreme Court would have created similar gobbledygook.
But we would have
as
had
they
an answer
today.
right now.
Well,
if she'd already done the hearing, we'd know right now.
They would have gone up to the Supreme Court, though, and I think
We'll never know. This is on
the
Earth.
appeals process would have
This
taken
is on
place,
Earth
but
too.
might not
All I can tell you is, having been covering the U.S. Supreme Court and their, just to go back to Bush v. Gore.
Yeah.
The reason that the conservative court in Bush v. Gore was able to do what they did is because the Florida Supreme Court let them.
Yeah.
The Florida Supreme Court made so many bad decisions and bad rulings, it was easy for the U.S. Supreme Court to come in and say, no, stop the count.
Yeah, what's interesting here, and there's a great line, I'm skimming it very quickly, in Justice Sotomayor's dissent, where she says, the majority pays lip service to this idea that the president is not above the law, and then in effect says that for certain official acts, the president is in fact above the law. It's how do you sort out what this actually means?
Let's do that right now, because in the oral arguments, there were certain examples that were given. Let's explore a couple of those and what today's decision means. First one was raised by Justice Sonia Sotomayor back in, was this April? What about getting SEAL Team 6 to assassinate a political rival? Let's roll that tape.
If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
That was a stunning moment in April. Did the court just say, yeah, you can assassinate a political rival?
No, I don't think they did. That's a ridiculous answer by Donald Trump's team, a dangerous and reckless answer. One really important thing, the basis for Donald Trump's legal argument that maybe he can order an assassination and still be okay is this preposterous argument that they offered below that, well, a president can only be indicted if he's first impeached by the House and convicted by the Senate. The Supreme Court explicitly rejected that argument. They said impeachment has nothing to do with this. That's not the test.
To your question, Jake, someone's got to decide what's the official act, right? And the challenge here, and this was what Sotomayor was getting at in her point, somebody has to make the call as to whether even the preposterous SEAL Team 6 example falls under the ambit of official acts, and that's litigation in months in court.
No, agreed. I think that's something that will have to be decided by the trial court if we were faced with that preposterous type of scenario, no doubt about it.
Jamie.
I just have a quick question for the lawyer. So one of the big concerns is getting evidence out in front of voters before November. We now don't think a trial
We're not gonna get it.
is possible.
No.
Is it possible, one lawyer just texted, would an evidentiary hearing be a way for Jack Smith to get some of that evidence out there in the public record?
Sure. So the district judge now has to have an evidentiary hearing. She can absolutely do that before the election. She can hear from witnesses. We're not going to get a verdict. I guess the judge will say some things were official or unofficial, but there's not going to be a convicted felon tag hung on Donald Trump for this case. I also should add, this is a major problem for the Georgia case because the factual allegations are very similar for Fani Willis's case. Now, that case is beset by its own series of problems, but now they're going to have to contend with this immunity problem as well.